Welcome to Advocating for Dads with Jana Jones. In this empowering podcast, we delve into the world of fatherhood and custody rights.
Welcome to Advocating for Dads with Jana Jones. I'm Sam Henninger, and I'm really excited to have another conversation with Jana. And we're going to kick things off with, Jana, you practice family law, you're advocating for dads. I want to understand a bit more, and you can just lay this out here in very simple terms, the differences between physical and legal custody when it comes to child custody and how each type impacts the child and parents.
Yeah, so they are different. I think that's the first thing to note. They get interchanged a lot, but they are technically two different issues. So legal custody is decision-making authority. Okay, so it's not where the kid's residing, it's simply decisions related to the child. So those can be things like what religion they practice, where they go to school, what procedure they get, what language they learn, any decisions related to the child, whether they have a passport or not, things of those natures, that's going to be legal custody. Physical custody, on the other hand, is where the child actually is residing. And in North Carolina, everything is based on overnights. So when we're talking about primary custody or joint custody, the magic number as of this recording in 2024, because things may change, is 123 overnights. Once you hit that number, then you have shared or joint physical custody. If you're at 122 or less, you have visitation, and the other parent has primary physical custody.
What other misunderstandings or just lack of knowledge do parents have about this distinction in legal and physical custody arrangements?
So I would say with legal, I think it's important to note that most judges are going to come off the assumption that joint legal is going to be in the child or children's best interest, which means that both parents should be able to equally contribute to decisions related to the child, regardless of the physical custody arrangement. So if you have one parent who has every other weekend and the other parent has primary physical custody, the parent who has every other weekend has just as much say in what religion a child practices, what school a child attends, what medical procedure a child has, as the parent who has primary physical custody. Now, there are a myriad of things that can come up when it comes to making decisions about kids, and you can't go to court every time you disagree. So what we generally have in a lot of orders is some kind of tiebreaker decision-making authority, or a mechanism that gets triggered when it's time to make those decisions and the parents cannot come to an agreement. So when you have a joint legal custody arrangement, that means that the parents are supposed to talk to each other about those decisions, go back and forth, weigh pros and cons, and hopefully come together to make a decision. But if it turns out that one parent wants one thing and the other parent wants the other, and there's joint legal custody, that decision-making authority, if one parent has it, is going to be what kind of breaks that tie. Other options available would be to do mediation or arbitration. Mediation is where you have a neutral third party going back and forth between the parties to kind of express what the other side is saying, to see if they can help them facilitate an agreement. An arbitrator is an attorney, but they kind of act as a judge. And so you put on evidence, as each parent puts on evidence, and the arbitrator makes a decision about whatever the parents are disagreeing over. So say you're trying to figure out which school the child's going to go to in the fall, and you can't come to an agreement. Dad wants one school, mom wants another. If your custody order says that you have joint legal custody, and if you can't agree that you have to go to arbitration, then each parent is going to have to kind of put on their case in front of the arbitrator as to why the school they want is going to be in that child's best interest. And then ultimately, the arbitrator is going to make a decision about which school the child goes to.
How does visitation and one parent having primary physical custody, how does this all work together?
So that 123 number is kind of the magic number when it comes to custody. So that 123 overnights is what shifts you from a joint custody arrangement to a primary custody arrangement. If you have 123 or more, if each of the parents has that, then you have joint custody. If you have 122 or less, then you have visitation and the other parent has primary custody.
Is that determined by what the parents actually end up doing, or is that more decided by the court order?
Right. So it really depends on where the parties are at. Sometimes people operate for a number of years without getting the court involved. And then something happens that kind of precipitates the need for a custody order, something more formal. Other times when parties split and have children, they kind of immediately go into the court system to get a custody order. So when you are dealing with those types of issues, as the parent, you want to get as much time as you can. You want to make sure that you're getting the time that you deserve and that you want. And if you're not getting that time, then you need to file a case in court.
What other considerations should parents keep in mind when it comes to negotiating custody agreements outside of court?
So I think it's really important to focus on the children. Not what you want, but what is best for your child. So if you work third shift and, getting up with the kids to get to school or to extracurriculars is going to be challenging and they're going to maybe miss out on some of that because of your schedule if they're with you, then that's something you need to consider when you're trying to figure out what kind of custody arrangement is really best for your children. Also, co-parenting is so important. Obviously, when parents split up, they're generally not happy with one another. Somebody's done something wrong. Maybe both of them have, who knows, but they're not happy anymore. But it doesn't negate the fact that they've got kids together and those kids still have things that they need, including both of them. And so the most important thing that you can do is focus on the children.
Give us an idea of what those kinds of conversations or considerations look like when it comes to having the child's best interests in mind.
So generally, I'm going to start with what is it that you want to see happen? What schedule are you wanting to, I often say, if you were writing the order, what would it look like? I believe in starting there. And then I believe in being honest. I'm a straight shooter. So if I think that the schedule they're saying they want doesn't make sense with the lifestyle or maybe the work schedule that they have, then I'm willing to have those hard conversations and make sure that they're prepared in front of a judge to explain why maybe something a little bit unconventional is still going to work and is still going to be in that child's best interest.
How can parents work together to create a co-parenting plan that supports the well-being of their child, despite differences in physical or legal custody arrangements?
I think the biggest thing that parents can do is put their differences aside and try to be as objective as possible when figuring out what's best for their children. If it's just going to be more practical and it's just going to be easier on the child to do a certain schedule, then I think that's the schedule that the parents really need to think about as being the one that's the best to want to implement.
Could you perhaps relate successful case that you've had recently, or just a notable one that can really illustrate parents working together to come to the best solution for their kids?
I am a firm believer in trying to get a case settled if we can. My kind of general premise when I'm working with a parent is I have them fill out a questionnaire that gives me a lot of detail and information. As I mentioned in the first podcast, the first step is always a consultation. And I'm taking some notes, but I'm not taking copious notes. I'm really just trying to get a feel for what you're trying to do, give you some value and some information, some next steps, because not everybody's going to be in a position to hire me. And some people may not be in the position to hire me yet because they've got plans, but nothing's changed yet, right? They're just trying to be proactive and get information. So I'm not spending a lot of time taking copious notes. Once they become a client, everyone gets a questionnaire to fill out. And that's where they give me a lot of detail and information that I use to draft pleadings, as well as a proposed consent order, because I think it's always worth trying to see if you can settle something amongst yourselves instead of throwing it in front of a judge and hoping for the best, right? So in the consent order piece of things, my client and I are going back and forth to craft an order based on what we want to see. And then we're going to present that to the other side, whether they're represented or not, to see if we can come to some sort of resolution. And sometimes we can because the other side isn't as far away from things as maybe my client thought. And we are able to work towards something that they are both happy with.
Jana, what challenges do parents commonly face during child custody battles, and how does having legal counsel benefit them?
I think information is power. I think that the biggest issue that a lot of parents have with these custody cases is not knowing what they don't know, not understanding how the law in North Carolina works, and not understanding that a judge is supposed to determine best interest, not what's fair to anybody, but what's in the best interest of the child or children. And like any job that anybody else does, you know what you're doing because this is what you do for a living. I practice law for a living. Most of my clients do not. And so the complexities that come with dealing with the legal system and the policies and procedures and the local rules, they're not going to be aware of. And this isn't about being smart. It's about having information. So at a minimum, I always recommend that anybody going through these types of issues always get a consultation because you just don't know what you don't know.
I particularly appreciate that because I think for most lay people who have not interacted with the courts or law in general, except when they need to as a client, there's generally quite a big difference between what somebody thinks as just the just and fair and common sense thing to do and what the law can actually provide.
Exactly. I often tell my clients, you are never going to be able to litigate your ex into being a better person. That is not the power of the court system. Who you have is who you have. What we can do is put some kind of parameters on what that schedule looks like and give you guys some footing on what to expect, give the child some stability, give you some stability so that you can make plans, vacations, etc. with the children, without the children. That is what the court can do. The court cannot fix the relationship. That is not the court's job, nor is the court inclined to. That's for therapy. We are here to create orders. It's important to know that when you're going into this type of situation. If you're hoping that getting the courts involved is going to help your relationship with your co-parent, that may or may not be the case. But what going into the court system will get you is an order one way or the other. And at least everybody knows what the ground rules are at that point.
What would you say in terms of, you gave a great synopsis, I think, of how first interactions work with you, with this initial consultation and then coming on as a client, what that questionnaire involves and getting started there. What else might you say in terms of expectation setting? Give a general timeline or what to expect next, and how do you set their expectations there?
Yeah, so it really depends on where you are in a case. If we're starting a brand new action, then we're starting with a summons and a complaint. Those are kind of the basics and the basic pleadings of any custody lawsuit. So you're going to need to know the address of the other party. That can sometimes be a challenge. Maybe the relationship is strained. Maybe you don't know their address for various reasons. Attorneys don't find people. That's what private investigators are for. So you're going to need that information. That's part of the questionnaire. And we can't file anything if we don't have an address. Now, what sometimes people don't know is you don't necessarily have to have their home address. If you have a work address, that could work. If they get their mail at their mom's house, we could serve them there. We can try at least. Mom may not sign for it, but we can try. But you do have to have an address. That is kind of one of those things that's practical that a lot of folks don't realize. And so it's one thing to definitely keep in mind as you're starting one of these types of cases. Once we have the information that we need in that questionnaire, I get started drafting the complaint, assuming we're starting a brand new case. And anything that I draft is going to be sent to my client for their approval before anything is filed. So once we have their approval, make whatever tweaks or edits we need to get that approval, then we file, and then we're sending it out for service. Service is the next big sticker. You can't start a lawsuit. The court doesn't even really recognize you have a lawsuit till the other side has been served, and they have to be served properly. So that's not shooting them an email. That is filing something with the court that proves that they have gotten that service in the way that the law requires. So generally, it's going to be certified mail return receipt requested. That green card has to come back with an affidavit of service. They can accept service in a couple of different ways. You can draft an acceptance of service. Recently, North Carolina has updated the summons, so you can actually, as the defendant, sign the second page of the summons and accept service that way. And then sheriffs can serve people, and then private process servers can serve folks as well. So I would say two things to kind of keep in mind. While they're not sexy, they're important. You need to know the address, and you need to be prepared to deal with the service issue and to understand that that has to be done properly before anything else can get started.
I appreciate that. And spelling out each of these steps before things can even get started, I think it helps paint that realistic picture of these things can take time. As we conclude, I'm curious, just another piece of advice you might offer to parents as they're beginning to navigate these child custody matters, and maybe they're unsure on where to start or what to expect.
The first step is always a consultation. No matter what, you don't know what you don't know. So the first step is that consultation. You should come out of a consultation with any attorney with an action plan to kind of know what your next steps are and what's realistic. I think it's really important to be honest with people and tell them if their expectations or what they're trying to do is unlikely to actually happen. So be ready for that. If you're going to somebody to tell you what you want to hear, that's not going to necessarily serve you well down the road. You're going to really want to get some honest information and be able to make an informed decision. So I'd say in conclusion, get a consultation.
Thank you again so much, Jana. I learned a lot, and I think our listeners did too.
Thank you.
This has been Advocating for Dads with Jana Jones. I'm Sam Henninger. Remember to like, share, subscribe, because we're going to continue having these great conversations.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.